Good evening. Welcome to Human Rights Lawyering. My name is Rosa Celorio, and I'm going to be your professor for this semester. I start by apologizing in advance that I am not able to be in the class with you today. However, I do have a work trip that has impeded me from being in class today. But I, at the same time, wanted to give you a flavor of what this course is about because I do hope that you choose to pursue it. Just a little bit of introduction about me before we actually start with the actual material related to this course. I'm a human rights law practitioner. I actually work as a full-time attorney for the Inter-American Commission on Human Rights in different capacities. I'm a senior attorney at this point. And I have about 15 years of experience working on human rights issues, both at the regional protection systems and also the universal protection system. I worked for the United Nations for a lengthy amount of time and for different international organizations. I teach because it's one of my passions, and I actually love being in the classroom with you, and I love interacting with students in general as well. In terms of this course, just to let you know, at its most basic, it seeks to present the skills and knowledge essential for lawyers in the field of human rights. It is a very interactive and pragmatic course. It features in-class exercises that are designed to hone critical skills such as interviewing, negotiation, legal drafting, and oral argumentation. And it's important to note that this is not a theory course. This is actually a lawyering and practice course. And the idea is that you actually gain some insight of what it is to be a human rights lawyer on a day-to-day basis. However, we will cover some aspects of history, theory, and case law, but always thinking of their practical application. The objective is not to provide an exhaustive survey course, but rather to build the conceptual foundation necessary for effective human rights advocacy. Okay, our book is going to be Philip Alston and Ryan Goodman. Please let me know if you haven't been able to find this book, because I will help you find it. And I will also be posting selected materials on the web portal. In terms of the grading methods, class participation and preparation is actually 40% of your grade, and this is very important. And it has two components. You have a weekly email submission every Wednesday before 9 p.m. based on the readings, and also attendance and active participation in class. With the weekly submission, it's important for you to know that I'm not asking for more than one paragraph per week, and I'm actually going to give you feedback twice during the semester just so that you have an idea of exactly what I'm looking for with these paragraphs. At its most basic, it's very important that I notice that you have read the readings, but also I want to hear a little bit about your personal reflections on the readings, reactions, and issues that you would like to discuss in class. It's important for you to know that I will add and subtract up to one grade step based on student participation in this class. And it's important for you to understand this since the beginning. Aside from the class percentage participation of your grade, you will be asked to perform 3 in-class exercises. And this is going to be 20% of your final grade. And these will be focused on interviewing, negotiation, and oral argumentation. They will actually be based on a case already admitted by the Inter-American Commission on Human Rights, which has been posted on the web portal. The case has the name of Mariana Selvas Gomez and others, and it is related to Mexico. It was admitted by the Inter-American Commission on Human Rights on November 2nd of 2011. It is better known publicly as the case of San Salvador Atenco, and it is related to the alleged torture and rape of a group of women by state agents in Mexico during a period of violent repression of social conflict in the municipalities of Texcoco and San Salvador Atenco, and the subsequent failure of the state to investigate these events. I chose these case in particular due to its legal complexity, but also for the fact that it's a very high profile case before the Inter-American system and in Mexico, involving very high level public officials in Mexico. The idea of selecting a case pattern and of tailoring these in-class exercises on one specific case pattern is for you to have the opportunity to work on the different stages of a case and to actually understand the process a case goes through when it has been presented before a regional human rights protection system, because this is important when you're a human rights lawyer. In terms of the three in-class exercises that we're going to be performing based on this case, and it's important to note also that this case is at the merit stage at the Inter-American Commission of Human Rights. The first exercise that we're going to be performing is related to interviewing to complement facts at the merit stage. We're also going to be performing a second exercise based on negotiating a friendly settlement agreement between the parties, since the state of Mexico has highly insisted on its willingness to resolve this case before a merits report is issued. And we will also perform an oral arguments exercise before the Inter-American Court of Human Rights, assuming that the case has already been submitted before the court by the Inter-American Court of Human Rights. Each of these exercises is going to require from you substantial preparation, including research on relevant law and procedures, and I will fully explain the methodology to be followed before each session. There's also a final 40% component of your grade. That's a final legal brief. And instead of a take-home exam, you will be required to submit this legal brief at the end of the semester. What I'm going to ask you to do is to prepare a merits report based on the Mariana Selvas Gomez case used for the in-class exercises. We're going to assume that this case will require a merits report. And I will give you examples of previous merits reports adopted by the Inter-American Commission on Human Rights that you can find in their webpage. And the idea of this brief or report will be to include a concise presentation of facts alleged by the parties, legal analysis of the human rights dispositions found violated, and recommendations for the state involved. It will require the research of human rights principles and jurisprudence. I have included in the syllabus some specifications in terms of format. It's not going to be more than 20 single space pages, and it will be due on Thursday, April 10th of this semester, okay, by email to my account. And we will talk more about this brief as the semester progresses. There are other classroom policies that I wanted to remind you of, especially because this is the first time we meet. Attendance is required unless excused. You are expected to speak in this class, and it is an important part of your grade. I will ask for volunteers in several classes to discuss certain class material or assign material to different students to present. It is a good way for you to contribute to your class participation grade if you volunteer. I do send emails, so please pay attention to your email. I will give you a 10-minute break in the middle of each class. And I want you to have a freedom in the class to advance your ideas and questions. For me, no question is too basic. This is highly complex subject matter, especially when we're talking about international human rights law issues, and we're going to be discussing many human rights issues as we move along this semester. And I do have a no judgment policy in the sense that you can freely express your ideas, and I want you to have the space to be able to do so without any sort of judgment, even if I personally don't agree with your ideas. I also wanted to take advantage of today to give you at least some basics on what we mean by human rights lawyer or international human rights law before we actually delve into more practical material in the following weeks. And I actually wanted to talk to you a little bit about international law in general, because human rights law is a subset of international law. International law was designed mostly as a set of rules and principles of general application governing the conduct of states and international organizations. And some traditional international law topics, particularly before World War II, include the treatment of foreign nationals regarding property matters within a state, the freedoms and privileges of diplomats, laws of war, minority protection treaties, and international criminal law, among other issues. And these were driven more by political and economic considerations rather than individual or humanitarian considerations. Probably the most important exception was noted by Professor Bergendahl in his article, the one that I had you assigned to read for this class. He mentioned international humanitarian law, and that's definitely an area of the law that wasn't so driven by political and economic considerations. However, it's important to understand that the distinguishing characteristic of human rights, and the reason why today we say that we have an international human rights law system, is that it seeks to protect individual human beings without regard to their nationality or other status. Its aim at the end of the day is the human being. However, it's important to understand that even though human rights is different from traditional international law, the sources of law are very similar. When we're talking about international human rights law, we're also talking about treaty and customary law as the most binding sources of international human rights law. And it's important actually to keep in mind treaties and custom when you're a human rights lawyer, because you will be arguing with states, you will be arguing with many sectors, and for some sectors, starting with treaties is very important. Starting with the most binding is very important. But it really depends on the specific scenario, and we're going to be exploring different scenarios in the class this semester. In terms of custom, because treaty, this is probably something that you have covered in your international law courses and other human rights law courses. Treaties are usually agreements legally binding between states, and I would say that the operative word here is that they're consensual. I mean, states actually agree to enter into these agreements. But there's also customary law, and it's important to keep in mind what custom is, which is evidence of general practice accepted by law between states. And usually refers to conduct or the conscious abstention of certain conduct of states that becomes in some measure a part of the international legal order. And some important elements related to custom are concordant practice, continuation of that practice, conception that the practice is required, and general acquiescence of that practice. But I usually like to think of three key words to keep in mind: general, practice, and accepted as law. However, aside from treaty and customary law, and we'll talk a little bit about this next time when we see each other, it's important to note, especially when you're thinking of international human rights law, that there has been a notable evolution and discussion of sources of international law, leading to the concept of soft law, which are non-binding norms of international law, but very important in human rights. Soft law tends to cover or supplement a vacuum in treaties, for example, and in binding sources of international law. And when we talk about soft law, we're thinking of resolutions and declarations of the General Assembly of the United Nations, just to give you an example. We're also talking about guiding principles, rules, codes of conduct, platforms, consensus documents agreed upon by a significant part of the international community. Just to give you an example, I can think of the guiding principles of internal displacement, the standard minimum rules of the treatment of prisoners, and also the general recommendations and comments issued by treaty-based organs of the United Nations, even though the treaties they supervise are binding. As a human rights practitioner, you usually use a combination of these sources to determine what human rights obligations are on a given issue, not only for the state, but for other actors. You will be reviewing a combination of these sources, not only for the preparation of your final legal brief, but also in the preparation of your in-class exercises. I also wanted to give you today a bit of some basics of what we mean when we talk about this international human rights system that you as a lawyer are going to be using, and what that system looks like today. And also, why are we talking today about human rights? Why do we say that we have an international law of human rights? A little bit of conceptualization issues before we delve into more practical matters. And I gave you the readings by Henkin and Bergendahl precisely to give you a flavor of what we mean by human rights today. In terms of the international human rights system, as Henkin explains in his reading, the concept of human rights developed mostly after World War II. and as a response to the atrocities committed in World War II. Even though, as Professor Bergendahl explains, it had some antecedents after World War One, especially with the creation of the League of Nations and the Minority Treaties. Most of what we regard today as international human rights law emerged after 1945, after the adoption of the United Nations Charter. The adoption of the United Nations Charter was followed by the adoption of the Convention on Genocide and what is known as the International Bill of Rights, and we'll be talking about this more next week. And when we talk about this International Bill of Rights, we talk about the Universal Declaration of Human Rights and the International Covenants on Civil and Political Rights and on Economic, Social, and Cultural Rights. And there have always been certain notions behind the human rights idea, as Louis Henkin calls it in his article, that are important to keep in mind when you study the instruments that are part of the International Bill of Rights, but also the treaties that we're going to be discussing in this class today. In the Henkin article, I actually like a lot when he refers to rights as related to the good, the right, the justice, and the good society. Pretty much implying that society is better if human rights are respected. He sees human rights as not philosophical but practical, needed in a society, and tied to goals such as peace, justice, dignity, happiness, and fulfillment. He describes human rights as comprehensive in nature, including both negative and positive obligations. And when we actually look closely at human rights treaties, we will see that most human rights treaties are a combination of these two sets of obligations. Human rights are also universal, belonging to every human being by virtue of their humanity. Human rights are also inalienable. Cannot be transferred, forfeited, or waived, cannot be lost by a failure to exercise them. Human rights can also be entitlements, and they're not aspirations. And there's an obligation of the state to satisfy human rights. And there's also an implication that the enforcement of civil, political, economic, social, and cultural rights requires state laws, policies, structures, services, and programs from the state. They require some sort of action from the state. I like when Henkin talks a lot about the idea of rights linked to remedies, because this is a resonant theme in international human rights law, that society must offer a remedy when human rights are not respected. He talks about human rights as fundamental but not absolute. For example, there are moments where human rights might need to be sacrificed for the social good, and other moments where there might need to be a balance between different human rights. And this is very true today, and I can tell you that as a practitioner. Limitations to human rights need to be closely scrutinized, and this is another resonant theme in the material that we're going to be covering this semester. For example, national security may demand the limitation of some rights, such as the right to circulation or the right to be free from deprivations of liberty based on arbitrary grounds, but there needs to be a reasonable justification. Also, restrictions based on prohibited grounds of discrimination, for example, on the basis of certain motives, such as race, are considered suspect by different domestic and international tribunals and demand a reasonable and objective justification from the state. Individuals also have obligations to others, and this is also a very important theme in human rights. And at the end of the day, if you take one thing from this course, I want you to always remember that human rights are about human beings at the end of the day. In terms of other basic material that I wanted to cover today with you, I want you to always keep in mind that there are some foundational documents to the international human rights system. And even though we're going to be talking mostly about these 9 core treaties adopted at the universal system level, that are pretty much the guiding treaties of human rights today, there are some foundational documents which still drive many of the principles and values espoused by the international community today when it comes to human rights. In terms of the foundational documents, we're talking about the United Nations Charter, which we discussed earlier. We talked about the Universal Declaration of Human Rights, which is still the constitution of the human rights system. We're talking about the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, and we will be delving as to why there is a division between those covenants. And there are some notions introduced by these treaties that echo a little bit of the principles advanced by Louis Henkin in his article. For example, human rights obligations are usually negative and positive in nature. States are not only obligated to refrain from committing human rights violations, but they also have the duty to create the conditions at the national level for their proper enforcement. There's also a duty to provide a special protection for groups that are at particular risk of their human rights violations based on their race, sex, age, political opinion, and migrant status, among other considerations. And some of these have been included in treaties. And some have been read into treaties, even though the language is not that explicit. And we're going to be discussing a little bit this in class, especially on the day that we delve into sexual orientation and gender identity issues. And there have been some cross-cutting principles since the beginning in the human rights system, like, for example, non-discrimination, equality, access to justice, the protection of life, the guarantee of judicial protection, for example, and remedies. And I wanted to close this class by talking a little bit about what we know today as the international human rights system. When we're talking about the system itself and what you as a human rights lawyer have to understand in terms of how to use the system, I wanted to give you a little bit about what institutions and mechanisms we're referring to. And these are the ones that we're going to be discussing at different points during the semester. It's important for starters to know that we're talking about a universal system of human rights, and we're also talking about regional protection systems. I work with one of the regional protection systems, but I've also worked with the universal system of human rights, so I can give you a little bit of a taste of both this semester. In terms of the universal system of human rights, it has been built around the United Nations and its mechanisms, and we're going to be talking a little bit about the United Nations mechanisms, the good, the bad, and the ugly, as I always call it. And we're talking about different institutions such as the Security Council and the General Assembly, but we're also talking about very interesting mechanisms to study when it comes to human rights lawyering, such as the Human Rights Council as well. And what's really interesting to note about the universal system of human rights is that we're talking about the United Nations mechanisms, but we're also talking about these 9 major human rights treaties that we know today that we're going to be discussing next week. And as Professor Bergendahl stated in his article, you can argue today that these treaties have internationalized human rights. Many have been widely ratified and can be viewed as creating an entire body of international customary law at this stage, even beyond the actual text of the treaties. But in my view, they also advance a set of principles and values that are important to the international community at this time. And this is very important when we delve on issues that are not covered by the specific treaties and when we are addressing considerations related to states that have not ratified given treaties. There are 2 components of the universal protection system that I want you to always keep in mind, and we're going to actually delve into these in detail. We have charter-based organs and we have treaty-based organs. The charter-based organs are those whose creation is directly mandated by the United Nations Charter, such as the General Assembly, the Security Council, and the Human Rights Council. And in contrast with treaty-based organs, they have a much broader mandate to promote awareness, to foster respect, and to respond to violations of human rights standards. And their legitimacy is derived from the human rights provisions of the Charter. They're very political in nature, even though their work has human rights implications, such as we saw with the crisis in Syria earlier this year, and earlier last year actually, related to the Security Council. We also have treaty-based organs, and those have been created by the human rights treaties originating in United Nations processes, such as those created under the International Covenants on Civil and Political Rights, and also Economic, Social, and Cultural Rights, and the other 7 core human rights treaties that we're going to be discussing in class in the coming weeks, such as the Convention on the Rights of the Child, the Convention on all forms of discrimination against women, the Convention on racial discrimination, and so on. And these organs are meant to monitor compliance by states with their obligations under those treaties. And their mandate is defined by the treaty they are monitoring. And it's important to understand that we don't only have a universal system of human rights, we also have regional protection systems, and it's very interesting to study them as a practitioner. We have a European system, we have an inter-American system, an African system, and an ASEAN system. And usually these are a reflection of the history, politics, and culture of said regions. The European, Inter-American, and African, they have their own treaties. The European has a very well-known court. The Inter-American and African have both a commission and a court, and they seek to supplement the universal system of human rights, and sometimes can be even more effective than the universal system of human rights. I have selected a hypothetical case in this class related to the Inter-American system of human rights, because this is probably the one that you're going to be the closest to, especially if you're practicing any sort of human rights law in the United States, because the United States is part of the Inter-American system of human rights. It's also next door, so I'm going to have you attend the hearings during the period of sessions. We're also talking about it's important to keep them in mind, even though we're not going to be discussing them in detail in this course. We have a series of specialized agencies that have been created within the United Nations system that do have work very intimately related to human rights, such as International Labor Organization, UNESCO, the United Nations High Commissioner for Human Rights, and the United Nations High Commissioner for Refugees, the World Health Organization, and their work is pretty much, most of their work is very relevant to human rights issues, especially the United Nations High Commissioner for Human Rights, because they're in charge of backstopping both the charter-based and the treaty-based organs that we're going to be discussing, the universal system of human rights. We also have international criminal tribunals, and even though the international criminal tribunals don't have as an aim to hold state responsible, because the state is usually the holder of obligations when it comes to human rights. And these international criminal tribunals have more of an aim holding specific individuals responsible that have committed pretty much violations of criminal law. It's important to understand that their work does have a bearing on human rights issues. In terms of the work of international criminal tribunals, it's important to keep in mind three in particular: the International Criminal Court, and the international criminal tribunals created to address the Yugoslavian and the Rwandan conflicts. And we're going to be touching briefly on these in one of our classes. And the reason why I think it's relevant is because their jurisprudence has been advancing very important principles related to human rights issues, even though this is not necessarily their competency. And the language of their creating treaties, especially the Rome Statute, which was the creating treaty for International Criminal Court, has very important language related to genocide, war crimes, and crimes against humanity that does have a bearing on human rights issues. It's important for you to know also the work of truth commissions, and we're going to be touching briefly on this later in the semester, which are typically set up to investigate large-scale human rights violations which have occurred in the context of an internal armed conflict or within an authoritarian regime. And we also have non-governmental organizations. It's very difficult to talk about human rights without talking about the work of NGOs. There's been an incredible growth of NGOs, especially in the last 40 years. And we're not talking only about Human Rights Watch and Amnesty International, but many international NGOs and local NGOs that are doing fantastic human rights work. We can talk about a human rights movement today. And this human rights movement has really been behind and responsible for many of the instruments that we're going to be discussing in this class. In terms of the effectiveness of the system, and this is a question that we're going to be talking about a lot during this semester, what is proper implementation of human rights obligations? What is implementation for you? What do we need for this system to be effective? And I would say that there are some hints that the system has a degree of effectiveness, and some of these factors were discussed in the article prepared by Professor Bergendahl. For example, today you notice that there are consequences for governments for not complying with their human rights obligations. A government can become an international pariah and have economic and social consequences for violating human rights today. For example, not being able to enter the European Union or other intergovernmental organization groupings. Human rights, I would say, are part of the government agendas today, even though there's always an application and budgetary issue there. We're going to talk a little bit about that, about this. You see every day more persons and victims of human rights violations claiming their rights individually at the national and international level. You do find human rights treaties as self-executing in many countries today, although not the case in a few of the major countries. You see this a lot in Europe and Latin America. I would say there's interesting evidence of compliance with decisions in some systems, such as the European and some in the Inter-American. And there has been extensive ratification of some international treaties. For example, the Convention on the Rights of the Child, the Convention on All Forms of Discrimination Against Women, and the covenants. I mean, they have more than 2/3 of the countries that belong to the United Nations have actually ratified these treaties, which is not a small detail. And but it's important to recognize, despite that, the fact that we talk about advances and we talk about some hints of effectiveness, we do have a long path to full compliance and extensive implementation issues, and we're going to be talking about those in class this semester. Well, this is all for now, but I'm very excited about this semester. I hope you stay in the course and that we get to spend more time together talking about these very complicated issues. I will be emailing you about the assignments for next week, and I'm looking forward to meeting all of you next Thursday. Good night, and I hope you had a wonderful holiday break and that you came back with a lot of energy to start the semester.